You're described on April 1st in a Star Advertiser article. You say that you believe that inmates on the list are nonviolent. Do you still stick to that assessment?
When we're referring to the April 1st, okay, first...
Your list are nonviolent offenders.
Yes. The lists that we provided, and we're talking about because of the petition, we were given a list by Public Safety, and I believe this is the list you're talking about. Public Safety provided us with this list. The Supreme Court ordered only A, B, and C are eligible. And A, B, and C, those categories, were nonviolent people on that list, or supposedly nonviolent, I want to say nonviolent people, people not charged with or convicted of nonviolent offenses.
When this first started, the public defenders had a list of originally 426 inmates they wanted for release. Of those, 137 were in Oahu. These inmates were supposed to be nonviolent, low-level inmates. At least 290 inmates have been released from OCCC. So you can see we have gone beyond these nonviolent inmates. All the examples that I'm going to give you, the motions asking for the release were based upon COVID, and the orders mentioned COVID. An individual charged with assault in the second degree, alleged to have struck a 74-year-old man multiple times with a golf club, breaking the golf club. He was released. Attempted assault in the first degree. Defendant struck the victim, allegedly struck the victim multiple times with a sword, cutting her face, arm, and hands. He was released. Hope probation. Defendant convicted of a burglary in the first degree and a terroristic threatening in the first degree. He violated a protective order, requiring him to stay more than 100 yards or at least 100 yards away from the residence of the victim. Victim came home, he was there, argued, broke her TV and other stuff, took up a bat and started swinging at her. Individual convicted of 7 counts of sexual assault in the second degree and 1 count of sexual assault in the third degree. This is what he pled to: knowingly subjecting another to an act of sexual penetration by compulsion. He also admitted to knowingly subjecting another to sexual contact of another who was less than 14 by placing his hand on her genitalia. Another person, Hope probation, convicted. Violation of privacy. He went into a bathroom, took pictures of people urinating. As the Attorney General said, there were about 45, 47 people who were either rearrested or got arrested because they were violating the terms of their release. Okay, and the interesting thing about it is some of the ones that got arrested is for burglary in the first degree, burglary of a home, robbery in the second degree. So these are the type of people who are getting released. And, and it's interesting that people talk about, just release them. Okay, the problem comes when it's time to bring them back, okay? You release them, no verified address, we don't know where they are. When they come back, we gotta test them, we gotta make sure they don't have it. I mean, all thought is given into releasing people. No thought is given into how we're going to bring them back. And they're one and the same.
At the current time, we're hearing from victims that are not wanting to participate in the system because they don't believe that we can protect them. I had a case yesterday where our victim witness counselor made a call to a victim of a domestic violence case where the guy was let out, and it's emboldened this guy so much to make a call to our office, to the victim witness counselor, telling our victim witness counselor that he killed her and buried her. We had to send the police out, and luckily that didn't happen. But who makes those kind of statements? People that feel that they can't be touched. And I think we're seeing that. We get complaints. I think I'm not just speaking for myself. I can probably say this for all the prosecutors. We're getting complaints on a daily basis from people about feeling, not safe in their own homes.
Our position here in Maui is we've addressed the COVID issues. We believe that there are no more, basically you've heard from the testimony, zero test results. And we are basically down to 55 inmates over the design capacity. We cannot go any further down unless we start jeopardizing the public safety. And that means releasing the hardcore criminals. And then we have this revolving door, just like what Mitch Roth is saying. We have this revolving door where new criminals are coming up and getting released, supervised release, and they're out there doing what they do best. This is going to be a problem. We will never be able to reach design capacity without jeopardizing the public safety. Just for the numbers, we started out with 450 inmates on March 2nd. And as of this morning, we have 264 inmates housed in the facility. All I'm asking, and I think most of you would agree, that this needs to come to light. This issue needs to, at some point, end, because we cannot go on with the process as it is now. We've had 50 releases here, 27 motions, and we've only won 8 of those. So 21 have been granted right off the bat over our objections. So there has to be a reason for that, because we're putting down on the record their background and significant risk issues to the judge, to our judges, but yet over our objections, they're granting these motions.
In this current time, the releases are being ordered by the courts, not by the Department of Public Safety, except for in some few limited instances which you may be aware of. And as a result, the victims have little opportunity to prepare, and they, particularly under current circumstances, have limited resources to be able to help protect themselves. And although there's been much discussion about what types of cases are being released and what are not, our victims are experiencing the releases in many cases that are far outside the scope of what we have been led to believe would occur. There has been no consistent, standardized, or mindful assessment of an inmate detainee's safety risk to the victims in our community or to the community at large that has been used to make these decisions.
That yesterday, when the House passed the judiciary budget, we included a provision that requires that the court provide to the legislature a full list of all those who have been released under these orders, and also whether they have been rearrested and for what crime. So that is all part of the requirements that we passed along with the judiciary budget and sent to the Senate, and hopefully that will be made part of state law.